Hello, everyone. Welcome to week 3 in the Masters of Technology Management Capstone program. This is Human Resource Management, NZACCARDI. So learning outcomes for this week are understanding the bona fide occupational qualification, BFOQ, sexual harassment definition and avoidance strategy, comparable worth, and equal pay in the workplace. Bona fide occupational qualification. There's going to be a lot of legal references here. The bona fide occupational qualifications are employment qualifications that employers are allowed to consider when making decisions about hiring and retention of employees. The qualification should relate to an essential job duty, that's a key word, and is considered necessary for operation of the particular business. The next paragraph in summary, this ties to race, sex, age, and national origin if these characteristics are bona fide occupational qualifications. It also ties to Title VII of the Civil Rights Acts of 1964, and it's an exception related to the discrimination clauses in those laws. So what are some examples? So safety comes into play here. So bus drivers and airplane pilots, there can be mandatory retirement ages for those types of jobs. Also in religious institutions, they can require that clergy or certain people that work in those institutions are from a certain denomination. One caveat here is especially on religion, it has to be tied to employment and executing those job duties. For example, a janitor that cleans the church or synagogue or other religious location does not have to be of the same religion, and that would be considered discriminatory. Other examples include models and actors for the purpose of authenticity or genuineness. It also ties into the requirement of emergency personnel to be bilingual, which is important to support the either patients or customers or consumers or certain demographics. So exceptions continued. So I did want to talk about physical ability. So certain jobs require a strength requirement. So that strength requirement could be tied to a more of a male demographic. However, I do want to reference the courts below. That's my note where the jobs need to be evaluated on an individual basis. So with regards to strength, there could be a female that is strong enough to perform the job. And if that's true, they need to be considered for that job. The next two examples relate to sex and privacy or preference. So for example, TSA agents tend to be the same sex of the individual they're searching when they have to do searches. That's related to privacy. That can also be related to a client or customer request. And then I like to give healthcare examples. From a healthcare perspective, we often see that patients prefer or request same-sex physicians or providers. It's fairly common in the healthcare arena. Next is sexual harassment. So I kind of picked this on purpose. It's a hot topic in the media today, in the news. I think we can use a reminder sometimes about how important this is. So from a definition standpoint, it's an unwelcome sexual conduct that has the purpose or effect of unreasonably interfering with an individual's work performance or creating an intimidating, hostile, that should be and/or offensive work environment. One key here from a court standpoint or a legal standpoint is the employer as well as the individual is responsible to enforce or enact sexual harassment policy. If that is not in place, then the courts they take that into consideration. consideration. So it just ties into it's an overarching process or responsibility here to both the employer as well as the individual and the supervisor of the employer. So I like visuals. I actually pulled this one from Pinterest. It was a Betsy Kim post from 2013, so it's slightly dated, but I think it summarizes the overall issue of sexual harassment. In 2011, there were $43 million in total payouts for sexual harassment. Uh, since then, and that dates probably only a couple years, it's reduced, which is great. However, the number is still high. One thing that I did want to point out here is the different businesses. So banking, finance, sales, marketing, hospitality, civil service, and then we're all in school, and education was listed here, which I was actually pretty surprised about. But it's listed as a business that there are challenges with sexual harassment. What constitutes sexual harassment? So this just gives some examples. Offering benefits for sexual favors, unwanted sexual advancements, any type of visual or verbal abuse, even suggestive gestures, any types of threats are obviously a problem, and then physical contact. That also correlates to assault, which is not a good thing. One thing that was surprising is the bottom graphic here is that there's been an increase in claims filed by men, which I found that to be pretty curious. Like I said, the data is slightly aged, but it's an interesting. So to continue with graphics, one thing here is that this is very surprising, and this correlates to all of us, is 70% of women were harassed by a supervisory or senior level employee, and 100% of them that were reported were male harassers. So we're all in a master's program for management. It's pretty baffling to me that this is still such a massive issue in the workplace, and that the primary offenders here are supervisory or management level men. So it's just something to be considerate and cognitive of. Who is responsible? So this ties to the court statement that I made. Employers are held liable when claims of sexual misconduct are made. I think all of us are responsible to understand the law and do everything we can to avoid these issues in the workplace. How can we do that? So an organization's policy on sexual harassment, what should it be made of? What should it do? So it needs to be clearly defined, so documented and defined, and it has to be very present that the organization prohibits sexual harassment. There should be encouragement that employees that have experienced this type of issue go forward to their management, preferably to HR, to an ethics board, to a safety board, in addition to just their direct manager. I think that's really important. And then in most of my prior jobs, we've had some type of online or classroom training. Classroom training can be difficult, but online training was mandatory. It reinforces the policy. There's usually a little assessment that's done at the end. Training should be required for employees to attest to that, basically signing off on that, and that that training or that assessment should go to their manager. That protects the employees in the organization, as well as the organization reminding employees what sexual harassment is, why it shouldn't be done, and what to do if it does occur. Moving on to comparable worth and equal pay, I also picked this because of the current news and the visibility in the media today. So what does it really mean? So this is the idea that every job has a worth to the employer and society. This worth can be measured and assigned a value. That value is usually through compensation. Each job should be compensated on the basis of its value and paid the same as other jobs with the same value. So from a strategic standpoint, organizations should have defined job criteria, and in the past we've used job coding that has a pay range within that particular code, and that's helped with the process of compensation for both men and women. Uh, this does tie to gender. I am focusing on gender with regards to this topic. Employers should evaluate whether there is any direct evidence of bias in setting wage rates, so that this can be done through audits. We do have an HR internal audit that happens annually that compares the wages between men and women in the organization for the same job codes. That's important. They have to be the same job. There shouldn't be any deviation from the evaluation system and the criteria put in place. So it's a standard for managers to have a specific criteria that they should follow, and then the audit, and aka job evaluation, can grade that and compare that, and we do it on an annual basis. I do want to highlight the Massachusetts Equal Pay Act really quickly. I'm not going to read through this, but it does reference retaliation. So, we all work in, I think most of us work in Massachusetts, or we live in Massachusetts. It does state that retaliation against employees who make complaints under the Act or participate in the investigation or hearing of claims under the Act is prohibited. So that's key to ensure that if this does happen, that it's brought to management. Some more legalese here that defines comparable work and working conditions. I do want to highlight the exceptions here. So, for example, experience is an exception. Experience tied to seniority in the organization, demographics, and education. So, for example, if someone works in Massachusetts or works in Arizona doing the same job, the pay could be different because of cost of living. And then education. So if you're performing the same job but you have a master's degree, you are entitled to a higher compensation than someone at the same job level that does not have a master's degree. So there are exceptions to the rule that I just wanted to reference here. So going on to references, we have several references that I have listed out here. Sorry for the long discussion, but with the legal aspect of these three topics, I did want to cover it in depth. So thank you all and have a great week.